Information fueled,
opinion driven. This is Nashville's Morning News with Dan Mandis.
And so, my fellow Americans,
we talk news.
708 Nashville's Morning News on Super Talk 99.7 WTN. Good morning to you, friends. Hope you're doing well. Along with Joan Jones and Johnny B, I'm Dan Mandis for your Thursday, December 5th. So, of course, we all know what's been going on around here with SB 1, Tennessee's ban on transgender procedures and surgeries for minors. And there's all kinds of audio making the rounds, and people are openly mocking, for example, Ketanji Brown Jackson, where she tried to make the case that this ban is akin to the ban on biracial marriage.
The question was whether it was discriminatory because it applied to both races and it wasn't, necessarily invidious or whatever. But, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at the structure of that law, it looks in terms of, you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So it's interesting to me that we now have this different argument, and I wonder whether Virginia could have gotten away with what they did here by just making a classification argument the way that Tennessee is in this case.
Yes, I think that's exactly right, that there is absolutely a parallel between any law that says you can't act inconsistent with a protected characteristic.
All right, so Tom Jipping is with the Heritage Foundation legal analyst. And Tom, I appreciate you being on with us, expert on the Supreme Court as well. So people are openly mocking Ketanji Brown Jackson and really the liberals on the Supreme Court for asking some of the questions that they did. Now, I'm no scholar. Clearly, I'm not a lawyer. But you're an expert in such things. Are people right to mock Ketanji Brown Jackson for that line of questioning?
No, I do think it's important to know that courts and legislatures and the media, for that matter, address similar issues in different ways. The point she was trying to make, the issue in this case is, what legal standard, what constitutional standard do legislation like Tennessee's law have to meet? She was trying to compare it to the Supreme Court's decision striking down Virginia's ban on interracial marriage, not so much because interracial marriage and puberty blockers, are similar, but that the standard being applied was similar. She was trying to shoehorn the issue of Tennessee's law regarding puberty blockers into the court's decisions about race and marriage. I hope that makes sense, because that was really what she was trying to do, and it's just not going to work. The fact is, race is constitutionally protected, gender identity is not. The two are not the same, and therefore different legal standards applied. While the Supreme Court struck down the law on interracial marriage, I think they're going to uphold Tennessee's law on puberty blockers.
So, yeah, and when I read that, because when you hear the audio from this or any other really Supreme Court hearing, you're right. They're always trying to find a legal way to connect previous cases to the current case as well, and trying to find those precedents and everything else. It did make a lot of sense to me, and I'm heartened to know that this was a swing and a miss for Ketanji Brown Jackson. Overall, as you watched this, you have other audio where you have, I think it was Sonia Sotomayor, and she's saying, well, all procedures and medicines and this, that, and the other, they all have side effects, just like aspirin. And people are saying that what she was doing was she was trying to compare aspirin, for example, to the side effects of chemical castration and some of these other things, these horrible side effects that kids that go through these surgeries and procedures have. And people are saying that is an absolutely ridiculous comparison.
Well, I would put that exchange kind of in the same category. I think the problem here is that the liberal justices like Sotomayor, Jackson, they're trying too hard. And they're really ignoring the way the Tennessee statute is written. See, what they're trying to do, at least what the United States is trying to do, the federal government brought this lawsuit in the first place, And the Solicitor General was trying, again, to make a comparison or a parallel. Her parallel was between the Tennessee law on puberty blockers and sex discrimination cases. Sex discrimination cases aren't subject to the same, to as high a standard as race discrimination, but it's higher than the ordinary standard. Legislatures can legislate the way they want in most cases, and it's only in some special categories where they have to meet a higher standard. The Solicitor General is trying to compare this to sex discrimination cases, and I don't think that's going to work either. And they're really ignoring the way the Tennessee statute is written. It's not discriminatory. It applies the same prohibition to boys and to girls. It doesn't matter whether you're trying to embrace a male identity or a female identity or anything like that. It's the same standard for everyone. So these comparisons to sex discrimination, race discrimination,
civil rights,
it's just not going to work.
7:15 on Nashville's Morning News. Tom Jipping is joining us from the Heritage Foundation, talking about our state's efforts to ban transgender procedures and surgeries for minors. Let me ask you, there were a couple of moments during the SCOTUS hearings yesterday where you had the justices and they were asking the Biden administration and the Solicitor General about some of the facts that they were trying to bring forward. For example, there was this moment, just so you know, Tom, I'm kind of a nerd. This was my favorite part of the hearing where they brought up the Cass report.
After the filing of your petition, of course, we saw the release of the Cass report in the United Kingdom, which found a complete lack of high-quality evidence showing that the benefits of the treatments in question here outweigh the risks. And so I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement that there is overwhelming evidence establishing that these treatments have benefits that greatly outweigh the risks and the dangers.
I, of course, acknowledge, Justice Alito, that there is a lot of debate happening here and abroad about the proper model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful.
So, Tom, I got to ask, they've been caught red-handed. There's also some studies out of Sweden that basically said the same thing. And so the justices are saying that the evidence and the so-called benefits that you're talking about in these studies, it turns out that what you're saying is false.
Well, there's two problems with what the Solicitor General tried to do there. Number one, she just completely mischaracterized what that research shows. This was not about the model of service delivery or anything as generic as that. The Cass report in the UK and a few others that have come out in Europe are about the real issue of benefit and risk. And, you know, the European countries were even ahead of the United States in jumping on this bandwagon that you got to take a kid's current feelings at face value, and you can literally fashion medical interventions accordingly. And then suddenly, when that all went off the rails, these countries in Europe, the ones that we said not long ago were right on the money, they're all backing away. The other problem, I think, with what the Solicitor General said, the reason that she was, that she had made those claims in their brief that the evidence is overwhelmingly positive, if they win on getting this compared to sex discrimination, and therefore the standard that Tennessee would have to reach is higher, those issues of risk and benefit and that kind of thing become more important. The proper way of looking at it is that there's no right to gender or whatever in the Constitution. The Tennessee legislature, like many other states now, is fully empowered to make these kinds of judgments and to make their own decisions about the evidence and risks and benefits. And so these were, I guess, the best arguments that the Biden administration could come up with. I'll have to say the Solicitor General is very good at arguing before the Supreme Court. I've heard her many times, but I just don't think these arguments are going to fly.
Well, one of the things I think it was Justice Kavanaugh said that, look, if Europe is backing away from this, then shouldn't we at the very least do the same and look at these issues with a lot more scrutiny, which is why they brought up the studies out of the UK and Sweden as well. All right, so now I know that the decision isn't going to be reached or announced until I think it's June or July of 2025. But knowing the makeup of the Supreme Court, our own Senate Majority Leader Jack Johnson, who's involved in all this, says that he is cautiously optimistic. I'm conservative, don't know where you fall, but do you have any indication as to what you believe the Supreme Court will ultimately decide?
Well, it is, of course, if I really knew how to predict Supreme Court decisions, I'd have a different job than I have now. But I think there's a majority of justices on the Supreme Court today who take the Constitution as it is written. They're not going to be willing to make things up in order to make policy decisions or to substitute their ideas for legislatures. And I think that there'll be at least 5 votes, maybe 6, for the idea that this is not some special category where the courts are able to take this issue away from legislatures, that the Tennessee and I really do have to applaud the Tennessee legislature. The way they wrote that statute, I think, helped prevent certain kinds of constitutional challenges to it, that legislatures like Tennessee are able to make these judgments for themselves. Now, I will say there's a second constitutional argument that is sometimes raised against statutes like this. It wasn't in this case, but if the Biden administration loses on the issue that was before the court yesterday, I wouldn't be surprised if some parents got together and launched another lawsuit making a different kind of constitutional challenge. So, it's not over. I think we may get the decision earlier than June if the court decides to, handle it pretty narrowly and kind of concretely. We might get a decision before that, but I don't think this will be the end of the road in terms of challenges to statutes like this. But the fact is, kids are different than adults, and while parents have wide authority to make decisions regarding the care and upbringing of their children, states do have the authority to regulate the medical profession and to draw some lines like this. And I'm glad Tennessee did, and I think it will be upheld.